finally a court order to update everybody on in the trial of the century, Crypto Open Patent Alliance versus Satoshi team, Craig Stephen Wright, and BTC Core. This is Gavin Mail coming at you. We're going to talk about that, and also we're going to refute some of the trolling that's going on the internet right now on Twitter, and just go through what the order says. All right, stay tuned. So check this out. So here's a summary. There was an order that came out. It's yesterday, the 20th. Today's the 21st on Thursday. This is the High Court of Justice, Business and Intellectual Property of England and Wales, Intellectual Property List. This is from a non-lawyer's perspective, okay? So here's what it says. Dr. Wright is permitted to rely upon additional documents referred to as additional documents in the trial. Point one. The trial dates and the timelines are revised as follows. 1 week of the judicial pre-reading in the week commencing January 29th, 2024. And then the trial hearing commences on February 5th, 2024. So with a 1 day of oral openings. Evidence will commence on February 6th and continue for 19 days up until March 1st. A 1 week break for preparation of closing submissions, with the closing submission scheduled for March 12th to 15th, 2024. So by the 18th of December, which would have been a couple days ago, Wright must provide specific disclosure of all the inspection of all documents containing advice given by Ontier, his former attorney. As mentioned in Ms. Fields got a witness statement here to COPA, the developer defendants. Number 4, by December 20th, by yesterday, Wright must provide Mr. Madden, which is the opposing party, a verified copy of forensic image of a Samsung drive containing forensic images of the BDO drive. Mr. Madden must not disclose those contents to anybody else of the metadata. So whatever is on that drive, Mr. Madden's not allowed to disclose it. It contains, and then the court, also by yesterday, Wright must provide COPA with developer defendants with inspection of a copy of the white paper LATEX files in native form on standard patents court confidentiality terms. By yesterday, Wright must provide all details on his LATEX environment used to COPA, including software, compile engine packages specified in the code, and relevant versions to allow reproduction of the computer environment mentioned in Dr. Wright's letter. Wright also must make a written request to authorize Overleaf to provide his legal representatives or experts with access to data held in relation to the white paper LATEX files. Then by today, the parties must exchange reply witness statements of facts and hearsay notices. Wright must serve his statement in reply, and then he also must serve an updated list of his reliance documents. And then by the 29th, each party must inform each other of the witnesses whom they do not require for cross-examination. By the 5th of January, COPA must serve an updated list on their challenged documents, including notice of alleged forgeries among the additional documents. And then by the 12th of January, Wright must complete his reply witness evidence by serving a further witness statement from himself. COPA is permitted to rely upon the third expert report of Patrick Madden, dated December 7, 2023. Both Dr. Wright and COPA are granting permission to rely upon further expert evidence, including forensic document analysis by expert evidence and latex software. And then by the 18th of 2024, Dr. Wright and COPA must exchange and serve expert reports on forensic document analysis and latex software to development defendants. So, all right, so that is a summary of what the order says. In context, it's case management. So there's been a change to the scheduling. There's going to be a slight delay. It's going to be starting now in February, discovery is open right now, and they're exchanging this discovery. So this is a discovery order, which is basically documents and evidence that need to be exchanged between the parties. Okay, then now there's a scheduling, which is going to be the case management side, the trial continue hearing, which will be commencing on February 5th. So that's going to be pushed back a little bit from where it was before. Now, again, non-lawyer's perspective. I have not seen if there's prior orders before this. I don't have access to them. This one right here, okay? You guys back this video up if you're not clear on what it was. That's what the order says. I summarized every key point right there. There's some people on Twitter now, and I totally open. I'm trying to come from a neutral perspective, all right? There's a guy on Twitter. He's a bar attorney, John Nicholas Gross. He's actually in the Bay Area, San Francisco. He's not too far from where I'm at. I would love to meet him in person in a totally humble, educated way. He's obviously highly experienced. This guy is a patent attorney and has been in this practicing at the state bar since 1988. Man, this is basically, he's been practicing law almost longer than I've been alive. Okay, so obviously this is a guy that I would like to learn from, and he's very experienced. He knows what he's talking about. He's made some comments on the Twitter about this case, which I'm always open to learning from an expert, but I've got to say, my perspective on this video here is not to really give you my opinion, because who cares about that? It's what does this actually say? What did the court say? Now, Mr. Gross here on Twitter, he's made a lot of opinion stuff about how the case is all over with now. He says the case is over and it's now wasting another 8x of lost cause and its career-ending reputational embarrassment. Okay. We're way out of, hey, it's your opinion, bro. I'm with you, Mr. Gross, but I would love to hear your insight, and I would come to your office in person to meet you, and we could do a podcast interview. I would love to hear your perspective on this. I invite you to. I will totally be neutral and open and learning from you and hear exactly what you have to say about this. Why? But it seems, but I would more like to actually have an analysis of the orders itself, not necessarily on how the case is over, because the case isn't over yet. It's not over till the fat lady's singing. She ain't singing until the trial date happening. So it's not over. None of this stuff is over. Not even close. Now his perspective would be great to have. I would love it. But I just got to refute the conclusions made, because no one knows what's going to happen in the court. And all of this discovery that's going back and forth right now is just that. It's discovery. The court's going through and sorting through what evidence is going to be considered and what's not. And just because the court ordered it to do something right here, there could be objections. Who knows? I'm not competent enough to understand exactly what these type of documents are. We've got some technical terms like, this latex files. I don't even know what that is. So whether what the relevance of that file is, obviously the court thinks the other side needs to see it. And so we'll see if that gets produced. We won't know. Some of this stuff, we won't even know if what's on the files. You got this one document here that the other side, Mr. Madden, is not allowed to share the forensic image of what's on the Samsung drive with anybody. So we won't know. Mr. Gross here in the Bay Area, he won't know. I won't know. Nobody's going to know. Only the court. That's only Mr. Madden, which is opposing party's attorney, and he's not allowed to share it with anybody. So it'll be interesting to see. That's privileged information on what gets provided, and then at what point do we get to see what is actually on some of this stuff. And this white paper latex files native on the standard patent court confidentiality terms. Nobody is able to determine what this evidence means yet, okay? It's like we can make bets on the upcoming Super Bowl, and we can say that our team's going to win. Makes a lot of sense, if your team has a better team and they paid more money, they got a better salary cap, a higher salary cap with much better players, and they had a better record. Hey, you have every right just to say that this team's going to kick that other team's butt in the Super Bowl. They're going to win. There's no doubt about it. We're going to win. We have a better record. It's all there. Hey, dude, root for your team, buddy. I love it. And that's exactly what's going on right here is Mr. Gross is rooting for his team. That's clear. He's rooting for his team, which is COPA, and he wants his team to win. Hats off. I love it. That's good sportsmanship. And so, my position is really try to stick more neutral and not say, oh, it's over. It's not, dude, it's far from over. There ain't no chance. It's not even close. I know that Calvin thinks it's over. Craig's already won. I get it. Calvin's the same way. He believes it's already over. Craig's won. This is a waste of time. COPA shouldn't even be wasting their time. It's a wide open opportunity now, and that they're suing Craig, and all this stuff is getting exposed. And that's great too. I love the bravado on both sides. So that's really where we're at right now. We got a lot of bravado going back and forth from people who have clout and experience. Mr. Gross, Calvin Ayre, and others. These guys have freaking done it, man. They have a lot of background and history that we should be respecting. Of course, definitely Calvin Ayre for sure. But now that I'm just reading about Mr. Gross as well, I would love to challenge him to, if not in person, I mean, I will be happy to come to you in person, Mr. Gross. If not, on Zoom, a call to get your perspective, man. I would get it out there, and in no way will I challenge you and say you're wrong. Obviously, you know way more about patent law than I would ever know. So it would be great to get your perspective, and hear a true interpretation of the entire case, because I know that there's another guy who's a patent attorney called Zem Gao up east down in Southern California who's saying exactly the opposite of what Mr. Gross is saying. So hey, here we go. Which team are you rooting for? It's clear on the Twitter wars as to which team they're rooting for, but hopefully this little summary here as to what's really going on in the order, that this case is only just getting started. It really hasn't even begun yet, but discovery's going back and forth, and the excitement is happening, and the gloves are going to be coming off now in February, and we'll then be able to determine. And again, to Calvin Ayre, I can actually go on February 5th. I actually was unable to attend in that January trial date. I have a case of my own because I have to argue before the appeal court myself on a case. So I will not be able to, I wouldn't have been able to go, but I can go 100% February 5th. I will be able to go if Calvin Ayre, in fact, wants me to go or sponsors me to go. CoinGeek authorizes me to go. I will be there. Looks like a lot of fun, and I'll be happy to, share whatever I learn at that time and talk to my man, Kurt. Gotta love Kurt, dude. All right, that's it. If you like this video, be sure to hit the like button, share it, get the word out there so we can have like a freaking more of a neutral point of view than as opposed to all these things. I mean, I'm just reading exactly my interpretation of what the case, that 12-page order says, fact by fact by fact. None of it says the case is over. None of it says Craig loses. None of it, that's not in there. Okay. So I could see that some people were saying that on Twitter. It's not even anywhere close to that. So I'll put a hand cash link in the video below. If you like this, you could freaking send out some Bitcoin SV. This is Gavin Mail. Be sure to subscribe. We're going to be at 100,000 subscribers next year for sure by this point next year on this channel. So I will see you at the top. All right.